Welcome again to another edition of Retrofitting International Structures for U.S. and Global Tax Reform. We're focused on drivers of change today, and we've got a micro topic we're going to hit because it's so current right now, which is the base erosion profit shift, or BEPS 2.0, OECD's blueprints on Pillar 1 and Pillar 2. The speakers with you today is myself, Bruce Stelzner. I'm an international tax partner with KPMG. And the keynote speaker today is Mr. Tom Zollo. Tom is one of our foremost international tax partners based in Washington National Tax and stays very close to topics like this. As we always remind folks, this session is dated. This session is being provided as of January 14, 2022. There's a whole lot of items that Tom's going to talk about that happen after the date of this presentation that folks should pay attention to, and we'll try and do updates. So with that, let's move to global tax reforms and the drivers of change. We've hit this in other sessions, so I'm not going to spend any time at all covering them. But really the key point here is we're going to talk about Pillar 1 and Pillar 2. And the most important to the folks listening to this most likely is going to be Pillar 2, because for the moment, Pillar 1 hits a much smaller population than Pillar 2. And so with that, I'll hand it over to Tom. Tom, why don't you take us off and give us a rundown on what's the latest and greatest in Pillar 1 and 2?
Two significant developments occurred. First, in October, the OECD put out a position paper that confirmed certain key aspects of the operation of Pillar 1. And second, on December 20th, 2021, the OECD published model legislation on Pillar 2's income inclusion rule and its backstop, the undertaxed payment rule. Also, on December 22nd, the EU published its proposed directive on the same topics. The scope of Pillar 1, what was confirmed? First, in-scope multinational enterprises with a turnover of above 20 billion and profitability above 10% are within the scope of Pillar 1. So that's quite a high threshold initially. It's intended to capture fewer than 100 multinational enterprises. That threshold will be reduced after 7 years, assuming that it operates in an administratively reasonable manner, to companies that have turnover of at least 10 billion euros. Also, the October statement confirmed that extractives and regulated financial services companies are excluded. Other key developments in particular are that the amount that would be subject to reallocation under Pillar 1 would equal 25% of the residual profits of the enterprise in excess of the 10% operating profit threshold. And the quid pro quo for the adoption of Pillar 1 would be that unilateral measures, that is digital service taxes, would have to be removed once implementation is achieved. For Pillar 2, the threshold for being subject to it is much lower. It's 750 million euros, which is the same as the country by country reporting threshold. And the new key developments is that the minimum tax rate that would be set under Pillar 2 is at 15%. That is the rate that will apply to the income inclusion rule and its backstop, the undertaxed payment rule. The tax rate that would apply to low taxed payments that would be subject to tax rule, which would deny treaty benefits, is set at 9%. Some other of the developments are listed here below. In particular, there is going to be a 5-year exemption for multinationals that are in the initial phase of their international activity. And as we'll discuss a little bit more later, in general, while the Pillar 2 income inclusion rule would come into effect in 2023, the undertaxed payment rule would have a 1-year delay and would come into force in 2024. This slide illustrates how Pillar 1 would work. So here we have P Company that operates in its home country, country 1, and it sells into 2 other countries. Country 2, where it has a subsidiary or an affiliate, QCO, that provides in-country marketing support, and also sells via the internet into country 3, so makes remote sales. Amount A, which is the tax that would reallocate 25% of the excess over the 10% operating margin, applies to remote sales. So in this case, PICO, if it meets the thresholds for application, would be subject to that potential reallocation on its remote sales into both country 2 and country 3. With respect to amount B, which is an amount under Pillar 1 that largely has had its development kind of fall by the wayside, there would, in addition, for sales that are made and supported by a local affiliate, be a presumed profit margin that ought to be recorded on those sales. So to the extent that QCO itself is not meeting that threshold in what's being reported locally, PICO could be subject to additional tax on those sales where it has an affiliate supporting its activities. Okay, Pillar 2 and its blueprint as it came out in October. Now, again, although Pillar 1 and Pillar 2 initially were supposed to advance in lockstep, in fact, that hasn't happened. Pillar 2 has gotten out ahead of Pillar 1. And within Pillar 1, the definition of the amount A has gotten out in front of amount B. So at least at present, we have a much clearer view of where we're going with Pillar 2. So I'm going to start on the right-hand side because what was released in December dealt directly with the income inclusion rule and its backstop, the undertax payment rule. So the income inclusion rule and what is called the switchover rule, which applies to branches, in the model legislation would trigger an inclusion at a shareholder level to the extent that the earnings in any foreign country, and you go on a country by country basis, didn't rise to the level of the 15% minimum tax that's been agreed. And the way the income inclusion rule would work is you'd first group all of the activities of the group that are in a particular country. You do a tax rate determination. If it's under 15%, then the difference, the profits, or the tax that would be imposed to get you up to 15%, would be subject to the income inclusion rule. And the income inclusion rule would apply on a top-down basis. So the ultimate parent company would have first right to impose the top-up tax. If it didn't, the next company in the chain would apply the tax, and so on. To the extent that the income inclusion rule does not top up all the taxes that were not subject to tax at the minimum rate, then the undertax payment rule would kick in. And the slide here says that the top-up tax would be collected by denying a deduction. In fact, the way that this has evolved, you wouldn't actually have to have a payment from a country to the low tax country for it to have a deduction disallowed under the undertax payment rule. Instead, as this concept has evolved, the undertax payment rule actually prorates the amount of profits that haven't been subject to tax at the appropriate rate and has a formula where it allocates out the deductions that need to be disallowed to the group members based upon a fraction that takes into account both the head count in the country versus the worldwide head count and tangible assets that are within the country. So it's evolved from actually looking at payments that are going to the low taxed affiliate and simply allocates out the deductions to the other group members. Now, one of the questions under the income inclusion rule is whether guilty qualifies for the income inclusion rule. And we'll talk about that a little bit more on later slides. But the basic feeling, and certainly this is borne out by the draft directive in the EU, is that our current guilty regime does not qualify. And it doesn't qualify because it doesn't operate on a country by country basis. Instead, you have a blending of foreign tax rates. In addition, the current tax rate, 13.8% or 10.5%, depending upon how you look at it, under the guilty regime is not equal to the 15% threshold that's been set under Pillar 2. The subject to tax rule is not covered by the December OECD paper, but the subject to tax rule applies before the rules that I just described, the IIR and the undertax payment rule. And what it will do is to deny treaty benefits for intragroup payments that have been subject to tax at a low rate. And for this purpose, the low rate is a 9% rate. And the subject to tax rule would be put into effect via a multilateral instrument. Okay, highlights from the December 2021 model rules that came out in December. Well, as I mentioned earlier, the income inclusion rule, the target effective date is 2023. The fact that the EU moved just 2 days after the OECD paper came out shows that they are serious about meeting this 2023 standard. The undertax payment rule, as I said earlier, would be delayed until 2024. One question is, well, what is left open? The basic form of the rules is really no longer left open as far as the OECD is concerned. The key features of Pillar 2, or at least the income inclusion rule and the undertax payment rule, are pretty well set. And what's kind of left open for additional public consultation are administrative aspects of the implementation of the rules. So what's coming next? Several documents are going to be released next year. 2022 is going to be a very busy year for additional activity on both Pillar 1 and Pillar 2. First of all, commentary on the model rules is expected to come out either later in January of 2022 or in early February. There's a draft that's underway that's already a 200-page document. And this commentary is going to be very important because for people who have looked at the draft legislation, it's like reading a dictionary. In fact, out of the 70 pages in the draft legislation, approximately 10 of those pages are just definitions. And as you read through the operative provisions, they rely very heavily on the definitions. So it's clearly not an easy read. As I said before, there are going to be public consultations on administrative aspects of the model rules, but I would not expect any changes in the substantive themselves. And there still needs to be work done on the subject to tax rule. We expect there to be a model treaty provision, so an MLI provision, that would come out along with commentary sometime in the first half of 2022. What is the impact of this on US-based multinationals? Well, let's start with the left-hand side. Assuming GILTI is treated as a qualified income inclusion rule, and as I said, current GILTI probably is not, but the version that was included in the Build Back Better Act likely is qualified. So as we sit here today, we don't know what's going to happen with those provisions. If there is tax legislation, it is probably pretty likely that it would pick up the international provisions of the failed Build Back Better Act, and we would come up with a GILTI regime that does work country by country. So that's really what we're talking about here on the left-hand side. So, you might think, well, in that case, we really have nothing to worry about because we're compliant. And that's not quite right. One of the things that can happen is that the United States itself could be a low tax jurisdiction. How could that happen? It could happen because, well, our tax rate is based on tax accounting. You determine the effective tax rate for purposes of the income inclusion rule based upon, in general, GAAP, although subject to, many exceptions. So the United States could still be low taxed. Also, the undertax payment rule could allocate to the United States some deductions that need to be disallowed. So that's another way that it could operate. And then we have the question of what would happen with the subject to tax rule. Could there be related party payments that don't meet the 9% threshold that the United States would then be expected to disallow as deductions under this multilateral instrument? And then finally, we have to think about the administrative requirements for compliance and what changes, that would require. If GILTI is not treated as a qualified income inclusion rule, which would likely happen if we did not amend the GILTI rules to go to a country by country, we still have all the problems that I just described on the left. But you also run into the issue that in that case, what the income inclusion rule would tell you is that the next company down the chain for US-based multinational ought to itself apply the income inclusion rule and apply a top-up. So we could have the simultaneous application of our GILTI rules and the income inclusion rule by a first-tier subsidiary. And that raises the question, which rule would apply first? Since the country of the first-tier subsidiary likely would apply the income inclusion rule, that may, in fact, top up the tax and could eliminate the US tax. Alternatively, you might have simultaneous application of the two rules in a way that would leave some rule for the GILTI rules to apply and some tax that's being picked up by the first-tier subsidiary. So, there is a lot here that provides an incentive for the United States to adopt the GILTI amendments that were included in Build Back Better. Otherwise, it may be ceding taxing rights to one of its subsidiary holding companies rather than taking that tax itself. Okay, so here's a Pillar 2 example. And in this case, we have a company, P company, that earns residual profit on its sales in France, where Q retains a distributor margin. And in addition, there are stripping payments that go out from PICO and from the US parent into Singapore, which may be offshore payments. So how would Pillar 2 apply? Well, first, you'd have to look at Q company and ask, what is the effective rate that France is applying? Now, based on the statutory rate in France, you'd think, well, no problem. However, as I said earlier, we're not applying local tax accounting. What we started out with is applying book tax, including deferreds, over book income. Now, having said that, that's generally what we do. When you look at the model legislation, there are about half a dozen adjustments that get made to the tax liability. There are also 15 or so adjustments that get made to the denominator, the income. Some of those are mandatory, some are elective. And so you really have kind of a whole different computation from either what France looks at from a local tax perspective or what may have been reported under US GAAP, for example. There also are rules that deal with situations, since we're going to use, in general, GAAP accounting for the numerator. What happens if the deferred taxes are not paid within a particular period? There may be the need to go back and file amended returns. So, a very complex computation in determining whether QCO in France has met the 15%. With respect to the payments that are going out to Singapore, if those are being paid into a Singapore offshore regime, Singapore is not imposing any tax. So the effective tax rate on the interest payments from PICO and US parent would be 0%. 0% is less than 9. That means that under the subject to tax rule, no deduction would be allowed either in the Netherlands or in the US for those outbound interest payments. This lists the activities going forward. And as I said, this is going to be a very busy year. So I'm just going to start with December, where the OECD released the model globe rules. Those came out on December 20th. As I mentioned earlier, the EU put out a draft directive 2 days later, December 22nd, that largely followed the OECD model rules. Assuming that this all moves forward, the Pillar 1 amount is intended to come into effect in 2023, as is the income inclusion rule and the subject to tax rule under Pillar 2. As I mentioned a couple times earlier, the undertax payment rule would be delayed until 2024. Now, from a technical track standpoint, there's a whole lot that's going to go on. As I said earlier, there's going to be an explanation that will come out on the model legislation. We expect that to come out in the next month or so. There has to be work done on the multilateral instrument that would implement the subject to tax rule. That's expected around mid-year. There's additional work to be done under Pillar 1 on Amount A. And then finally, the laggard in all of this is what Amount B is going to look like. So remember, Amount B, unlike Amount A under Pillar 1, is the amount that would apply a normalized operating margin in each country where a multinational sells, where it does have some kind of local sales affiliate or a customer relationship entity that's rendering some services. And what that would do is it would bring up, particularly in the case of stripped risk, low margin distributors, the amount that's being reported locally by having the other group entities be obligated to pay an additional amount. Now, what's not clear under Amount B is exactly how broad it's going to be. It could be so broad that it applies to all market countries and basically implies a certain expected distributor margin. On the other hand, the OECD has indicated that the focus of Amount B is primarily on developing countries. So there's a lot of ambiguity about the scope of Amount B, its reach. It could be quite broad. It could apply to many consumer and industrial companies, or it may get scaled back and have relatively limited effect, largely to sales into developing countries that are the market countries. Okay, this is the last slide in this portion of the presentation, and it just lists the expectations for what are going on. And, I've described a lot of those. There's a lot of work that's going to be done on Pillar 1. We're going to see documents out on Amount A, which has moved out ahead. It's going to put a lot more meat on the bones as to how the amount potentially subject to reallocation would be allocated, how losses would be carried forward and offset the amount that is available for reallocation. It would deal with a marketing and distribution profit safe harbor. It would have to deal with the administrative certainty, and it would have to further define the excluded industries. So, there's a lot that needs to be done in Amount A. But having said that, there's a lot more that needs to be done for Amount B. There's going to be a public consultation document issued sometime in mid-2020 that will give us the first idea about how broadly Amount B is likely to apply. And then that will be followed up with more concrete proposals later in 2022. But the plan, is to get both parts of Pillar 1, so both Amount A and Amount B, back on track so that 2023 would be, in general, the implementation date for the bulk of BEPS 2.0. The only exception at this point being the delay in the undertax payment rule out into 2024. So that's where we stand right now. Keep an eye out. These rules are certain to change, and they're going to change very quickly as we get closer to that January 1st, 2023 expected implementation date.
That was absolutely fantastic, Tom. Clearly, there's a lot that's been going on. There's a lot to come. As we've mentioned, Build Back Better Act, BBBA, had a major component of it, which was the country by country GILTI and FTC limitations that were attempted to be proposed and legislated in the last go around of a tax act. You may see that arise again in whatever form it may appear, whether it's in a mini BBBA or something that the GOP picks up next year, or whoever's leading Congress next year. Point is that right now, our GILTI provisions are not conforming with Pillar 2. And if they're non-conforming with Pillar 2, we have, as Tom mentioned, an averaging type calculation for tested income and foreign tax credits. So not really a min 15% tax, and as well, GILTI's at 10.5%. If we don't fix those bits and Pillar 2 moves forward, the U.S. is going to abrogate its taxing rights to the next lowest holding company that will pick up the income in their min tax system. So we would expect some form of change coming in our tax provisions, or Pillar 2 falls off the shelf, which is probably at this point unlikely given the momentum that is out there. So with that, I'll say be on the lookout for more retrofitting sessions. We'll be discussing ATAD 2 and the different fabrics that impacts, from DREs to financing structures, as well as IP planning and country modules. So thanks for taking the time. Thank you, Tom, for an excellent presentation, and we'll see you all next go around.